Seated. Good morning. It's the time set for argument in cause number 22-0406, Montana Trout Unlimited versus Montana Department of Environmental Quality and the state. Council ready to proceed? Mr. Schoengert. Oh, I might mention that both Justices Baker and Justice McKinnon are participating, and they are participating remote. And from time to time, I'm sure you will hear them asking questions.
Mr. Chief Justice, and may it please the court, Dale Schoengert for Tintina, Montana. We're going to split argument today. I'm going to do most of the opening with Mr. Hurwitz with Mark County, closing out the opening, and Mr. Langston with DEQ will do the rebuttal. We want you to reverse the district court's ruling and fully reinstate the permit, and here's why. By failing to accord the exhaustive scientific record and professional judgment of the agency any level of deference.
Excuse me, Mr. Schoengert.
Yes.
Can you pull that mic a little closer to you?
Sure.
Told you you'd be able to hear them.
Is that better? By failing to accord any level of deference to the agency's professional judgment and the scientific record, and by accepting the plaintiff's contentions literally word for word, the district court simply, effectively, and improperly substituted its judgment for that of the agency's. In cases like DeBuff, Clark Fork Coalition v. DNRC, and most recently Water for the Flathead's Future, this court has said that's improper. Our briefing gives the roadmap to the extensive and lengthy record showing how the agency dealt with each of the contentions raised by plaintiffs and found them scientifically unsupported and unsupportable. And we can talk about that. But not to argue that the agency is right and the plaintiffs are wrong. That's never the function of a reviewing court in a case like this. The only question is, did the agency take a hard look at the project and apply its professional judgment to every issue? It did here on every issue. I'd like to start with the tailings storage facility or embankment and the tailings. DEQ sent the Tintina's application back 3 times. It extended a 5-year review of this project that amassed 90,000 pages of an administrative record. It was reviewed by nearly 50 experts in diverse fields. Yet the district court concluded that that review was arbitrary and capricious. It only got to that result by evaluating the science and DEQ's conclusions, not the process. Under the MMRA and MEPA, the DEQ is required to evaluate the science and weigh the evidence. Courts are allowed to evaluate the process. Here, the district court take the tailings storage facility itself. DEQ, Tintina, the outside consultants concluded that the tailings storage facility by itself is sufficient to safely contain these tailings regardless of what form the tailings take. It's designed to withstand a doomsday catastrophe, a 1 in 10,000 year earthquake with, at the same time as a 1 in 10,000 year flood, followed immediately by a 1 in 100 year snowpack melt. The engineer of record was explicit in this, and we've discussed this in the brief, but I want to point out one site, 46844. The engineer of record concluded that this mine, the factor of safety for the tailings storage facility is so high and so far exceeds what's required that it's not even necessary to analyze what's going in the facility. Now, of course, they did. Tintina did. DEQ did. Outside consultants did. But any risk of failure was simply not credible. Importantly, plaintiffs don't contest the safety and stability of the facility. They acknowledge it. They acknowledge it at district court, and they don't contest it on appeal. No, instead, they look at the extra regulatory safety redundancies, the cemented paste tailings, and they attack those. In fact, I think it's important to point out that every contention by the plaintiffs in this appeal, except for the independent review panel, is against extra regulatory safety redundancies, not required. And if plaintiffs are successful, it actually will make mining less safe in Montana because no mine would ever undertake these extra precautions when they don't have to, if it's just going to be a basis to hold up the permit. The district court looked closely at and weighed the evidence, and that was the problem. It looked at the slump test, the bench test, the HCT test. It looked at the binder composition and the ratio to cement. The fact that those tests were done, those analyses were done, and DEQ reviewed them, that should have been enough. The problem was that the district court delved into the science and instead acted like a fact-finding court rather than a reviewing court, which was its role in a case like this.
I understand your argument, counsel, and the district court's order is filled with a lot of discussion about competing scientific analyses. I understand that. But also, there are several rulings by the district court that I have tagged as purely legal, purely process-oriented. For example, on the topic that you're talking about, the tailings facility, it held that the administrative record shows that the independent review panel never reviewed because Tintina never created the construction management plan that's required by statute. So isn't that a technical legal problem with the review regardless of the science involved?
For the independent review panel, yes, that was a technical process review or conclusion. The district court was wrong, and let me tell you why. First, if you look at the controlling statute, 82-4-377 sub 9, it requires that the district or that the engineer of record submit the plan and all the underlying analysis to the independent review panel. The independent review panel then looks at that, makes recommendations to the engineer of record, which it did in this case. Specifically, it recommended additional analysis on the dam breach analysis and the seismic analysis. The engineer of record did that. It confirmed the initial analysis in the documents, and then the engineer of record submitted that under 377 sub 10. The first time that the phrase complete design document is used is at the end of that process. It's designed by statute to be an iterative process. It's not one and done by the independent review panel. Now, the district court, in plaintiffs and the district court, I think, elevate form over substance in this because when DEQ reviewed this plan, as they're required to do, and reviewed the engineering or the what was required under 376, and they said everything's complete. Is it in one comprehensive document? No, but the components are there. And the construction management plan, was there a document that labeled construction management plan? No. If you look at 376 sub M, the components of the construction management plan, pretty general. They were covered in the Tom's manual. Plaintiffs accused us of double counting the Tom's manual, but the point was that the components that were required were there. And DEQ reviewed that, like I said, found that the components were there, albeit could have been maybe organized differently or labeled differently. That decision is entitled to deference as well. That is subject to abuse of discretion standard, just like every other issue in this case, meaning that is it random, unreasonable, or unmotivated by the record. And DEQ, and specifically on the tailings storage facility, and this independent review panel, let me again, because sort of one of the things that becomes apparent in this case is how far above and beyond Tintina went at every level in this mine. Part of that was the independent review panel itself. No one questions these are the most respected experts in the world when it comes to tailing storage facilities in their diverse fields. They have a collective 120 years of experience. They stake their reputation on the safety and stability of this facility. They also were involved in this project much earlier than what was required by statute. And they even mentioned that at AR 1544 and commended Tintina for it. They conducted a site visit, not required by statute. They went beyond what was required because they wanted to give this purposeful, meaningful analysis. And that's also why they went back and forth with the engineer of record, MEAGHER recommendations. The tailings themselves, and the district courts, and let me point out one area where the district court clearly got into the science. When you're talking about the composition, whether it's liquefaction or oxidation, let me point out that other mines in Montana use tailing storage facilities only, right? And they put liquid, basically slurry in them. Those mines are permitted, those mines are safe. Tintina went beyond by putting...
Some aren't. I mean, oxidation, excuse me. Some are, some aren't. Oxidation is an issue with a lot of mines.
Oxidation can be an issue, but there's no indication in the record that any of those mines are being compromised. Now, they may need to be adjusted, but that's one reason that Tintina incorporated cemented paste tailings. And the record's clear that cemented paste tailings are used by themselves. So the Tanzania mines mentioned in the record, they're just stacked on top of each other in thin lifts without cement in a field, essentially. Tintina took that technology and put it within the tailings storage facility. Either one of those by themselves would be sufficient. The mine combined those two technologies to provide for, literally their goal is to provide for the safest mine in Montana's history. DEQ gave this mine the most extensive analysis of any mine in Montana's history. The district court, though, quibbled with things like whether to separate pyrite and the percentage of binder or cement in the binder. For pyrite, the DEQ, this was an early topic by the working group, which we mentioned in the briefs, that assembled very early to discuss this. They ranked that as not a good option. Tintina's consultants further studied it. DEQ studied it. DEQ then commissioned a outside consultant, said, we want you to check our math. Take a look at this issue. The outside consultant, Environmental Resources Management, said it probably causes more harm than good. It's not feasible to separate it, and when you do, it causes problems. You should study it more. DEQ did study it more, came to the conclusion that it was not a feasible option. That was not random, unreasonable, or unmotivated by the record. DEQ did exactly what it was supposed to do. Now, is there competing evidence in the record? Absolutely, and there better be. If the fact-finding process went as it's supposed to be in a project like this, there should always be competing evidence. But that's what DEQ is doing in resolving the issues to come to a conclusion. That's what this court has said it's supposed to do. That's not what the district court is supposed to do. District court did the same thing with the percentage of binder, similar process. Tintina studied it. Tintina's consultants studied it. DEQ studied it. Came to the conclusion that a range of 0.5% to 2% binder was ideal, optimized on site, depending on the ore characteristics and the weather. DEQ didn't stop there. They hired an independent consultant, check our math again on this. The independent consultant came to the same conclusion, said that additional cement wouldn't serve any purpose and it would cause harm. Again, DEQ followed the process, did exactly what it was supposed to do.
I'm sorry to interrupt, but the sound quality is not terrific, and it helps a lot if everyone speaks really directly into the microphone, including my colleagues when you ask questions. Thanks a lot.
I'll work on that.
So, Mr. Schillinger, hopefully, can I ask you a question?
Please.
So I'm looking at the appellee's brief, and it notes that the district court characterized the rapid oxidation observed in the weathering test, rightly identified DEQ's irrationality failing to require to discard the results of the only testing conducted on oxidation, which is the weathering test. Can you address that?
Sure. First, the point, Tintina did test percentages of binder. They tested 0, 2, and 4. And what they found was that the range of ore characteristics reacted differently, which is why they allowed the range of cement. So they allowed that range because sometimes 0 cement performed better than 4%, and DEQ goes into this in their brief. What DEQ looked at is the HCT tests were far more aggressive than what would be in the field, and that's clear in the record, and DEQ knows how to interpret those. The district court doesn't. DEQ interpreted that, applied it, also looked at mines like the Tanzania mine, which plaintiffs hold up as an example, and we agree it's a safe mine. They deposited tailings in thin lifts, paste tailings without cement, and there's oxidation. Because what the district court, and this gets a little bit into the science, but this was the problem with the district court's opinion. For oxidation, permeability is the main problem because there may be oxidation on the thin crust on the top. That's not an issue as far as disaggregation. The problem is the issue is keeping it not permeable. Here, the permeability is like 10 times more impermeable than bedrock, as we discussed in the briefs. District court didn't even address that. That is DEQ being DEQ, and that's the problem here, that the district court didn't. And, you know, it's easy.
I think the district court did note that there were problems with the oxidation analysis and that she identified and she referred to the record to oxidation paths and persistent cracking, which would allow the oxygen to penetrate below the tailing surface. And I think that was a general concern in the whole process with the district court.
The district court was misreading the study that she was even referring to. The same study noted that the pH, even if desiccation cracks occur, the pH didn't drop. There wasn't a problem with oxidation that would destabilize the tailings. That's DEQ's role to evaluate that. And second, keep in mind, the other tailings are liquid slurry. So they're always sort of subject to disaggregation. Here, DEQ did a very thorough analysis, and I'm reminded of this court's memorable statement in MEIC2. The court's not comprised of hydrologists, geologists, and engineers. And, you know, candidly, it's easy to think that, it's easy to get comfortable with the science. I've been studying this for over a year now, and got pretty comfortable with it. And then when I talked to the engineers, hydrologists, geologists that evaluated this project, I'm reminded pretty quickly that I'm an English major with a law degree. And the point is that DEQ has the expertise to analyze this. The question is, did it analyze it? Did it take the steps it needed to take? Clearly it did here. The district court nitpicked some of the conclusions, but with respect to the district court, it didn't have the skill or the competence to do that. And it's outside its role, most importantly. It exceeded its authority. I'd like to address very quickly the evaluation of total nitrogen in the discharge. This is another example of Tintina going above and beyond what's required by the regulations. First, this begins, the water after purified by this double pass reverse osmosis is drinking water quality. Tintina could have discharged directly into Sheep Creek, turned it off July 1st, and we wouldn't be here on this issue. They took the more protective route by incorporating the underground infiltration gallery that slowly infiltrates water to Sheep Creek over 5,400 feet of stream bed. The plaintiffs are attacking the finite amount of water that's in the UIG, the underground infiltration gallery, after the water's turned off. What the district court misunderstood both the science and the governing standard. The standard here is a monthly non-degradation standard. It's extremely conservative, and it was developed by DEQ. DEQ knows how to apply its own standard. This court's reaffirmed it. When an agency is applying its expertise in a technical area to a limit or standard that it developed, the deference to it is at its absolute maximum, and for a good reason. It knows how to apply its own standard. Here it looked at that finite amount of water and concluded, based on the review of the evidence and the studies in the record, that it would not exceed that monthly average. And in fact, the evidence shows that it wouldn't even be close. First of all, the district court incorrectly included, other than disregarding the monthly average, the district court overlooked that also would be subject to groundwater mixing and attenuation. Attenuation is when plants and microbes absorb nitrogen. That's the whole point of the underground infiltration gallery. It's well studied. Plaintiffs say that, well, the studies in the record involve wetlands. Ours did too. I point to AR 32-657. And as we discussed at page 22 of the reply brief, the lowest rate of attenuation in those studies, it would drop that total nitrogen level well below the non-degradation limit.
A significant issue for the district court in regard to this topic is the timing of the discharge and whether there could be delays that would mess up sort of this calendar schedule of discharge. Could you address?
Sure, and I'm glad you brought that up, because that was key. The district court charged DEQ with overlooking this amount of water that was in the UIG after July 1st, and saying that it could take months to get to Sheep Creek. DEQ in its comments addressed exactly that and said that's the point. If it's quickly, it's not going to be an issue, and it resolves any of plaintiff's concerns. If it takes longer, it gives more time for that slow infiltration to work and attenuation to work. In fact, it said that's the point. So, and we just addressed that at some length in our briefs and show that where DEQ made that, responded to that comment in the comment period, and it specifically addressed that. Finally, DEQ also is requiring ongoing monitoring to look for trends and to adjust make any adjustments that are needed to make sure that the surface water is protected. In close, everybody agrees that the Smith River is a treasure, and that's precisely why Tintina sought to design the safest mine in Montana ever. That's why DEQ gave this project the most exhaustive review of any mine in Montana ever. That fact is established by the 90,000-page administrative record in this case. Here it was error for the district court to take a hard look at the science rather than simply confirming that DEQ did. This court should reverse and reinstate the permit. Thank you.
May it please the court, counsel. My name is Bert Hurwitz. I am the Marr County Attorney, and I am arguing on behalf of the county interveners here this morning. I have just a couple of, I'll be arguing for about 2 minutes. First of all, the highest priority for each party before you today is the protection of Montana's natural resources, specifically Marr County's land and water. The locals who live in Marr County choose to do so because of these natural resources. They would not support any project that put those resources in danger. Agreement number 2. The Montana Supreme Court in its history has not heard a case that will have a more direct and measurable impact on the residents of Marr and Broadwater County. That's why it's such an honor for me to be arguing here before you today. Agreement number 3. The plaintiffs, their members, their experts, their volunteers, all made this process better. The commissioners of Mar and Broadwater County observed this process for the 5 years that it took for this to move through the back and forth. And at the end of that process, they determined that, yes, this is a project that can change Montana's mining history, that can put out, and they were so confident in that they asked Corey Swanson and I to intervene on behalf of development of this project. And number 4 agreement is that this is the administrative record that is the result of this good process, is everything that you need to decide this case. I think what we disagree about is what the court can do with this administrative record when you go from a 90,000 plus page record to about 1,000 plus page final environmental impact statement, to a 35-page complaint by the plaintiffs, 4 hours in front of Judge Bittigary and 70 minutes in front of the Supreme Court. When you have something that is so ultra distillated into this small of a process, the only thing that I believe the court can do is to adhere to its long-term standard of determining whether the DEQ took a good hard look at the important issues that were raised by the plaintiffs in this case. And I think the administrative record will show that it did. What I think the plaintiffs are asking you to do is the impossible, and that is to, no matter how they couch the terms, they're asking you to determine what is the appropriate amount of binder to put in these cemented tailings. Why can't a facility designed to hold liquid tailings hold cemented paste tailings? My final point is just that at the bottom of this stack of administrative record, 3 years of litigation, 5 years of this record, is a private property owner in Mar County who pays property taxes, who has a constitutional right to use their private property. And the intent language from the legislature in both the MMRA and MAPA is to balance those things. And that is what the DEQ did in this case, is to seek balance. Don't accept a false choice. There are 2 things that can be true in this case: that the process that is before you protected the Smith. It protected Sheep Creek. It protected all of the unnamed springs and tributaries in Mar County. And that this mine can be done in the heart of Mar County safely and environmentally soundly. Please reverse the district court. Thank you. We'll reserve the rest of our time for rebuttal.
Good morning. May it please the court. Jenny Harbine on behalf of the conservation organization Appellees. We are here because DEQ failed to reasonably evaluate the safety and stability of Tintina's proposed 72-acre mine tailings impoundment, and to reasonably evaluate harmful nitrogen discharges to Sheep Creek, which is a major Smith River tributary. I'll first address the safety and stability issue. And the glaring problem here is that DEQ never tested or evaluated the actual condition of the tailings. DEQ based its safety and stability findings on an assumption that the tailings would be non-flowable because of the addition of cement. But while Tintina plans primarily to use a 0.5% cement mixture with its tailings, DEQ studied only the less risky mixtures of 2% and 4%. There is no testing, nor any competing evidence, as Mr. Schoengard characterized it, evaluating 0.5% cemented tailings. The amount of cement is critical to determining whether, as DEQ assumed, the tailings will become and remain non-flowable. On this fundamental issue, the district court was correct to conclude that DEQ simply didn't do its job under the MMRA and MEPA. Mr. Schoengard described these statutes as fundamentally procedural, or this court's review of DEQ's compliance as a review of the process. But fundamentally, the process and the information gathered under those statutes must be sufficient to allow DEQ to apply its expertise and to meet its substantive obligations. And here, its obligation under the MMRA was to require the applicant to ensure that all proposed waste impoundment structures are safe and stable. And under MEPA, DEQ has to provide assurance, a level of assurance that's commensurate with the seriousness of the risk that such impacts won't occur. And so we've heard about this hard look standard, but under this requirement of MEPA, and it's at ARM 17.4.601, DEQ's MEPA rule, it meant that the agency had to take a hard look that was designed to provide that assurance, that severe and potentially catastrophic and permanent consequences from a potential failure of Tintina's mine tailings impoundments would not occur.
So, Mr. Schoengard said the plaintiffs don't contest the safety of the tailings containment. Is that accurate?
I believe he said we don't contest the safety and stability of the facility, which is absolutely inaccurate. The appellants have this revisionist argument that somehow achieving safety and stability didn't require non-flowability of tailings. Mr. Schoengard said today that was an extra regulatory requirement. But the record is crystal clear that DEQ counted on solid non-flowable tailings for nearly all of its safety and stability findings. Mr. Schoengard pointed you to the record at page 46844. On that page, DEQ said, was addressing the risk of liquefaction and said, we don't need to perform this analysis because the tailings will be non-flowable due to the addition of cement. And similarly, for the required dam breach analysis, which is the analysis that looks at what happens if the rock impoundment fails, DEQ said at the record at page 46235 that the solid tailings, quote, will not flow into the environment. And the cementation would preclude the risk of widespread release in response to impoundment failure or seismic events. Non-flowable tailings is the defining feature of this tailings impoundment.
Counsel, you're all familiar with the science of all this, but what are you referring to when you're speaking of non-flowable tailings? What does that mean?
What DEQ believed it meant.
What do you think it means?
What I think it means is based on my understanding of the record, and the record says that non-flowable means that if the impoundment breaks, that those tailings won't be released into the environment. It's to achieve structural stability, and that was the fundamental design feature for this cemented tailings facility.
What is the record danger or risk of that happening?
The risk of the impoundment failing?
And causing these tailings to become flowable in your terms?
I think we would characterize the probability of that happening as low and the risk as severe. So here, if the impoundment fails, then you have highly toxic, acidic mine tailings. And we know, based on the history of mining in Montana, what happens when those tailings are released into the environment. And that's why in 2000...
I understand the consequences if there was that type of failure in your view, but what is the, in your language, probability, the chance in the record of that type of thing happening under the engineering that has been put forth here?
The Tintina's experts said that the chance of an impoundment failure is low. The MMRA requires this belts and suspenders approach because of the very serious consequences in the event of impoundment failure. So in 2015, the legislature amended the MMRA to require heightened review requirements for high-hazard tailings facilities such as Tintina's impoundment. And those require specific design standards, review standards, certification standards, and at the end of all that, DEQ has to determine that the applicant provided sufficient information and then determine that it provided assurance that the impoundment wouldn't fail. So the MMRA embodies this precautionary principle in response to mine impoundment failures elsewhere.
I understand that. That's the legal aspect of this. What I'm having a hard time getting my mind around with your argument is precisely where is it that you assert that DEQ's compliance in its analytical approach to the engineering data that's been submitted is deficient?
Plaintiff's argument is that DEQ didn't require analysis of the actual conditions of the mine tailings, and therefore couldn't be assured that its assumption that those tailings would be non-flowable would actually come to pass. And this is not dissimilar from the court's recent decision in the Flathead Lakers case or its 2010 decision in the Aspen Trails case, where the court recognized deference owed to agency expertise, but nonetheless said the agency has to gather the adequate information to apply its expertise to. And if it fails to do that, that's a problem under this court's standard of review. And here, DEQ absolutely failed to do that because Tintina says most often we're going to use a 0.5% cement mixture. And DEQ never required analysis of that cement content. And it's important for issues such as one Justice McGrath raised of oxidation and acid generation. It's important for the setting and drying time of the tailings and resulting stability.
They don't seem to dispute that. What they seem to be saying that I can glean from this is that there's an explanation for why they didn't do that, and that it's not arbitrary or capricious. And I guess I'm trying to understand how you see that differently.
Let me talk about the specific issue of oxidation to get at the answer to your question, because we don't see an explanation in the record. What we see in the record on oxidation is Tintina did testing on this issue because it's important. We know acid generation is important when you're mining sulfide ore. Tintina's testing showed that even with a 2% cement content, tailings are susceptible to acid formation and resulting disaggregation. Now, Tintina's solution, and this may be the explanation you're pointing to, is to layer fresh tailings on top of that impoundment every 7 to 30 days. And they say that will preclude conditions for oxidation. But when Tintina tested 2% cemented tailings, they found the tailings crumbled in just 28 days and became acidic within 2 weeks. And while these data are alarming enough, testing further showed that the lower the cement content, the quicker the acid formation and disaggregation occur. And despite this, Tintina never tested, and DEQ never required testing, of 0.5% cement. So for all we know, as one geochemist opined in the record, that lower cement content of 0.05 or 0.5 could immediately become acidic and disaggregate or crumble, which is what happened with the uncemented tailings.
Ms. Harbine, how would you have this court address that concern? Require the HCP test with the 0.5% binder?
We would request that the court declared that DEQ failed to take a hard look by failing to require Tintina to conservatively evaluate the full range of conditions it expects at the tailings impoundment, and therefore failed to meet its obligations under MEPA and the MMRA to provide assurance that that tailings impoundment will be safe and stable.
So, but
then-
specifically, what do you want them to do? I mean, we would send it back and do what would meet that in your mind?
As I look at the record, I think DEQ needs to require testing of the 0.5% cemented tailings, or require that Tintina's impoundment design actually match the testing that it did do. It would be up to DEQ on remand to evaluate what further steps are necessary to meet its statutory obligations to provide that assurance.
Ms. Harbine, so that addresses one aspect of the district court's, and I think that falls into the area of process rather than the district court actually, there's a deficiency there according to you and the district court in terms of the process and the flowability. But the testing of the 0.05 tailings and the cement addition isn't the only problem with the flowability. Is that correct?
That's correct, although I think all of these flowability problems do come down to the question of the level of cement that will be included in the tailings.
Well, wasn't there a lot of issue about pouring the tailings on top of, in layers before the layers completely dried, and how that potentially affected flowability?
Yes, absolutely.
If we were to send this back, I mean, I guess I'm trying to see, I understand where the process may have been deficient, or that's your argument, but that, in terms of the 0.05, but there are other areas that are maybe not where the district court has weighed into the scientific analysis, but is saying that there's a deficiency in the process. Can you identify those areas?
Yes. As to the drying time issue, the testing that is in the record, again, is for 2% and 4% tailings mixtures, and those are for the final set time of the tailings. And Tintina, again, plans to layer fresh tailings on top of the impoundment every 7 to 30 days. There's evidence in the record that that layering can actually inhibit the drying time of lower layers. And so the question here is, the only evidence we have in the record is for the final set time, and even then, it's only for 2% cemented tailings. The glaring omission on this record is whether the tailings will be sufficiently dried or set before new tailings are added, in order to achieve non-flowable conditions and ultimately structural stability of the tailings facility. And there's no evidence, and this gets at the cement content, there's no evidence of what the drying time or the final set time is for tailings with the addition of just a 0.5% cement binder.
So the 2 to 4 is roughly 28 days, is that, I mean, did I see that in the record?
Actually, in 2%,
Yeah.
for 2%, it's 28 days for final set.
Okay, so 0.5 is, we're assuming based on that, is somewhere between 0 and that. I mean, so it might be more than 7 days is what you're telling us. And
Exactly.
if they dump it in every 7 days, it will just stay liquid in the bottom, which if you have a earthquake or something is really a problem.
Exactly, and it's important to remember this will happen layer after layer. And so we don't know, based on this record, whether or when those lower levels would eventually dry. And I'll point out on the timing issue, the testing showed 28 days for final set of 2% tailings, and I believe 14 weeks for 4% tailings. And so we know that it's highly sensitive to the cement content in the tailings.
So the higher cement content was a longer period, is what you're saying? For
Oh, I'm sorry, thank you for pointing that out.
14 days? is
Okay,
what
with
you meant?
4%, the tailings reached final set in 4 days. I was confusing it with the acidification issue. And with 2%, the tailings reached final set in 28 days. So we can expect it to be longer than 28 days. And, you know, there's an unavoidable tension here with the acid generation problem and the set time problem. Depositing new tailings too infrequently risks acid formation that could cause those tailings to crumble. But adding new tailings too quickly means that the lower layers may not have dried sufficiently to create a non-flowable condition before new tailings are added. So it's really important that Tintina balance these tensions and get this timing right. On this record, DEQ can't tell us what that correct balancing is, but more troubling is DEQ can't tell us whether that balance is achievable at this facility with these issues. And the third issue related to structural stability of the cemented tailings is their potential for liquefaction, which, you know, is typically what happens where solids flow like liquids in response to agitation, such as earthquakes or blasting. And the danger here is that, for example, a major seismic event could damage Tintina's rock impoundment and simultaneously liquefy the tailings stored there. And the results of that occurrence would be catastrophic. But DEQ said, we don't need to do a detailed liquefaction analysis or liquefaction analysis because the non-flowability, the cementation of the tailings eliminates this risk. But the only evidence in the record on this is for backfill applications of cemented tailings, because those are the only field-tested conditions for cemented tailings. And it's observed that at least 1% cement content is required to prevent liquefaction. DEQ simply assumed that 0.5% cement would be enough on this issue, and that was also arbitrary.
Because you're referring to the Portugal, I'm drawing a blank on the name, the Portugal mine that was using 1%, is that correct? Was
That's
that set, it wasn't clear to me whether that was set as the minimum or that was just what was adequate for the Neves Corvo mine, whatever. Right,
and it's at the record. It's in that environment study that's cited frequently in the briefs at page 40802, and it said at least 1% cemented tailings is necessary in backfill applications to prevent liquefaction.
So Mr. Schoengert also said that the mine is designed to withstand the earthquake and the 1 in 10,000 years snowpack melt, and that y'all didn't really take an issue with that. Is that accurate?
We haven't challenged the stability of the rock impoundment. We've challenged only this fundamental issue of the non-flowability of the tailings. And the MMRA requires this, as I called it, a belts and suspenders approach, to say, well, if in that really unfortunate circumstance where you have an earthquake that destroys the rock impoundment, what happens then? And DEQ threw up its hands and said, we don't need to worry about it because the tailings won't flow out of the rock impoundment. So
Ms. Harbine, how does the liner, the double liner, play into this belts and suspenders approach?
Thank you, Justice Baker. The liner is essential to prevent the liquid that collects in the impoundments from entering groundwater and eventually surface waters in this area. It doesn't affect the circumstance where an impoundment, where the rock impoundment might fail.
But you're not challenging the adequacy of that, the impoundment. The liner would be part of the impoundment, correct?
I would say the impoundment is the collection of these different control strategies. We've challenged one of the control strategies, and it's the one we think is most fundamental to DEQ's safety and stability findings. I want to address briefly this independent review panel issue. The MMRA sets out heightened design, review, certification requirements for high hazard tailings impoundments such as Tintina's. And to begin, throughout the permitting process, DEQ operated under the legally erroneous belief that Tintina's cemented tailings facility was exempt from these heightened requirements. And DEQ explicitly refused to evaluate Tintina's compliance with these requirements as a result. And it's because of this that appellants are left trying to piece together evidence of compliance from various parts of the record. But these haphazard efforts fail to show compliance with a regulatory scheme that the legislature designed to provide maximal protection. And I mentioned the legislative history here, where the legislature was responding to high-profile, catastrophic failures of tailings impoundments across the globe, and it established very specific design standards to be evaluated and approved by an independent review panel, which then certifies its review and approval to DEQ. Appellants point to a letter in the record from July of 2017 to satisfy these requirements. But DEQ told us that the design document that the panel reviewed in July lacked basic information: the seismic hazard analysis, the dam breach risk assessment, and the construction management plan. Tintina attempts to repurpose and piece together other record documents to claim compliance with these elements. But as discussed in the briefing, and as evidenced by the record citations that Tintina provides, in some cases, these documents on their face don't meet the requirements of Section 376 of the MMRA. In some cases, they were provided to the review panel only after the fact, after July 2017. And in some cases, such as the seismic hazard analysis, the documentation doesn't appear to have been provided to the review panel at all. The Black Butte Mine is the first test of the legislature's heightened review requirements for high hazard impoundments such as this. DEQ's failure to insist on compliance shouldn't be allowed to set the bar for future mine reviews, and it was unlawful.
I'd like to ask you some questions about groundwater, if I could.
Okay.
So the proposal is, as I understand it, that the operation would discharge 398 gallons per minute into Sheep Creek, or as much as 398 gallons per minute. But that before that happened, it would go through a reverse osmosis process, filtering process that would, according to Mr. Schoengert, make the water drinking water quality. And then it would go through the UIG, the underground filtration gallery. Then it would flow into Sheep Creek, and there would be alluvium filtering with that. My first question would be, do you agree with those conclusions? And if so, specifically, why not? And then two, perhaps most importantly, isn't continuous monitoring of Sheep Creek, which I understand is required in the permit, alleviate those concerns?
To answer your first question, I don't agree, and most importantly, there's no evidence in the record to support this determination. DEQ evaluated the nitrogen content of Tintina's discharges after it flowed through the alluvium and found that nitrogen would be 4 to 6 times the non-degradation standard that applies in the summer months, as high as 0.57 milligrams per liter, where the non-deg standard is 0.09. Then even when the water mixes with Sheep Creek, with the surface water, it still exceeds the non-degradation standard, and it's as high as 0.12. So the analysis that is in the record shows that even after the water is treated, flows through the alluvium, and then mixes with surface water, it will exceed the non-deg standard. And it's not just a number on a page. DEQ said any elevation of nitrate, which is a component of total nitrogen in the surface water, will contribute to the nuisance algae problem that anyone who's ever floated the Smith in the summer months knows is already a problem, and it kills fish. And that's why DEQ required holding the water during these summer months rather than discharging it to the UIG. It simply didn't contemplate this lag time problem, and its reliance on attenuation and dilution after the fact is insufficient to meet its obligations to ensure that significant impacts will not occur.
So,
Why wasn't that issue challenged in the MPDES permitting process?
The problem here is that the MPDES permit prohibits discharges of mine effluent in excess of the non-degradation standard, but the fundamental error was one in the MEPA process that didn't evaluate whether that prohibition could be met. Chief Justice McGrath, you asked about why monitoring isn't sufficient. Because we have a system that is highly engineered to accommodate, these different environmental problems that come up with mining. And if nitrogen is in excess of the standard, the only solution is to discharge, to stop discharging earlier in the year. Well, if they do that, it causes problems for their aquifer recharge under their water rights permit. It causes problems for their water balance, which is part of the delicate design that Tintina is trying to achieve to meet all of its various environmental obligations. But it was DEQ's obligation to take this hard look, to ensure that the analysis was done, to ensure that these various design components would actually achieve the environmental protection that DEQ claims. And before I conclude, I want to reiterate that the assurances demanded by the MMRA and MEPA demand the application of the precautionary principle. When we're looking at a standard of assurance, it's not enough to say that there's a pretty good chance that this mine will operate as planned and that environmental harm will be avoided. That's not what the statute requires, and that's not good enough for the Smith River or its tributaries, which have irreplaceable value to Montana fisheries and residents alike. We ask you to affirm the district court, including the stipulated partial vacatur order, to ensure that these resources are protected.
Langston, I think you have yeah, 1246.
Good morning, and may it please the court. I'm Jeremiah Langston, appearing on behalf of Defendant Appellant, Montana Department of Environmental Quality. I first want to go over the overall design of the tailings facility, just to make sure that every protective measure that's put into this is clear. First, there's an embankment. This is essentially a dam that is holding back these tailings. And as we've acknowledged, this is designed to withstand a 1 in 10,000 year earthquake simultaneously with a 1 in 10,000 year flood with a 1 in 100 year snowpack. That's the main thing holding back these tailings, not the tailings themselves. Additionally, there's a double layer polyethylene liner that prevents seepage of any water that gets into these tailings. There's a pumping system that removes any water that gets into these tailings. And finally, there's the cemented tailings themselves, that in the event that these other protective measures fail, they will slump out of place. Ms. Harbine described the cemented tailings as a fundamental safety feature. That's not true. They're only relevant and they only come into play when all of these other measures fail. And thus, it cannot be contended that that's the fundamental safety feature of this project. I want to turn to this court's recent decision in Water for Flathead's Future, particularly paragraph 24, where it said that the reviewing court must look to all of the relevant information in the record and must examine the entirety of DEQ's rationale. Many of MTU's arguments here today ignore DEQ's rationale and additionally invent new irrational factors that it supposes the agency should have looked at. For instance, turning to the issue of set time, Ms. Harbine just came up and said that the tailings have to reach final set for the facility to be non-flowable. There's nothing in the record that says that these tailings have to reach final set. What's more, the record is clear.
Pardon me, I'm not sure that's exactly, or the entirety of her argument. I think her argument was that we don't know how much they will have set before the relayering if we haven't tested the 0.5%.
Well, I think there's different issues here, Justice Baker. So the tests that she's referring to are the slump tests, and that refers to the structural integrity of these materials. And it's notable if you look into the record, and we described this in our briefing, those materials that were subject to the slump tests did not reach final set. Indeed, if you look at the pictures of those slump tests, you can see that the materials are still wet. So the testing that DEQ did on these materials assumed that they wouldn't reach final set. Indeed, DEQ also clarified this issue on the subject of oxidation in responding to MTU's comments, explaining that set and final set are not the same thing. And what's more, DEQ was balancing this issue alongside the issue of oxidation, pumpability of the tailings, and dust emissions. DEQ had to consider a whole host of competing factors in arriving at its approval of this project.
But why wasn't it tested at 0.5%?
Well, Your Honor, Justice Shea, it was tested at 0%, and the results revealed that tailings with 0% binder but higher solid content performed better than tailings with low solid content and 4% binder. So the percent of binder that's in this material is not a panacea. It's not the only thing that DEQ looked at. It had to look at a whole host of competing interests, and as we explained in our briefing, there wasn't an unlimited amount of tailings material to test. There's only a certain amount, and Tintina and DEQ had to make judgment calls as to what intervals should be tested. There's the even intervals of 0, 2, and 4%, and as this court said in Park County Environmental Council, the agency, when it offers up legitimate scientific explanations, can decline to conduct additional testing.
No, and I understand that, and I don't dispute that, but I mean, it seems like there's no dispute that the most common percentage that will be used in practice is the 0.5%. Is that correct? Or so it just seems to me like, you know, given the limited amount that you had to test, I mean, let's test what's actually going to be used at the 0.5 instead of, you know, saying, well, what is it going to be at this percentage? And I get the kind of bookend argument, you know, we're going to test it at 0, 2, and 4, but it just seems like if it's going to be done at 5, 0.5, that would be one of the numbers that you would test at.
Your Honor,
procedurally.
I see the rationale that you're getting at, but I think it's important to keep in mind this wasn't the only lens DEQ evaluated this issue. Also evaluated this issue with the competing interest of oxidation, with pumpability, with preventing dust emission. At the end of the day, the binder amount is not the end-all be-all. It's certainly a consideration, but the court has, as it said, and as you recently said in Water for Flathead's Future, you have to give credit to the agency's analysis it did offer and not allow alternative, irrelevant analysis that plaintiffs think should have been done. There's no doubt that DEQ did take a hard look at the issue of ensuring that this facility would be non-flowable. Turning to liquefaction, MTU's arguments are similarly premised on an irrelevant notion, specifically that 1% binder is necessary to prevent liquefaction. But this is irrelevant to these particular tailings because this concerns backfill tailings. Backfill tailings have to go underground and support the weight of the earth. They have different compressive strength requirements than surface tailings. I mean, there are going to be people working alongside these backfill tailings, and they sure have to hold up the tunnels that are underground. So it makes sense that you would include higher binder amount and be more concerned about liquefaction. Additionally, MTU's arguments ignore DEQ's analysis on permeability. DEQ specifically addressed this issue under the lens of permeability, and it said the specific measure of permeability in these tailings is sufficient to prevent liquefaction. So here's another example. DEQ offers a rationale. Plaintiffs ignore that rationale, invent their new rationale that they think DEQ should have looked at, and suggest this court should overturn on those grounds. But as this court said in Water for Flathead Future, you have to give credit to the agency's analysis. Turning to the question of oxidation, Ms. Harbine just came up here and said that there is nothing in the record that supports DEQ's analysis on oxidation. That simply isn't true. DEQ looked at this issue again through the lens of permeability, and DEQ found that the physical characteristics of the tailings would prevent formation of acid. Specifically, if you can't have oxygen and water enter the tailings, then there's going to be no acid formation. And that's the criteria DEQ looked at in evaluating this issue. And again, this court needs to give credit to the evaluation that DEQ offered. MTU contends that DEQ should have conducted additional testing under the humidity cell testing, which is where these cylinders are subjected to extreme weathering and we see how much acid formation occurs. But as this court noted in Park County, the agency can decline to conduct additional testing when it offers a legitimate scientific explanation. Here, it did just that through its permeability analysis. It said it's not the chemical interaction that matters, it's the physical character interaction. And indeed, MTU in its answer brief says neutralizing binders have little impact on acid production in high sulfide tailings. That concession strikes at the heart of their contention that additional HCT tests should have been conducted. I want to talk a moment about the IRP process. And Justice Rice, you asked Mr. Schoenger, isn't this a legal conclusion? Isn't this just sort of seeing whether something has checked the statutory box? And I think if you look at the process, it becomes apparent that it's not just strictly a legal conclusion. Specifically, these materials were handed over to DEQ staff. And DEQ staff looked through all of the materials that were provided to the IRP and determined that these satisfied the statutory requirements of the IRP statute. Specifically, and we cite this in our opening brief, you can see a colloquy between our staffer and Tintina, basically going from, okay, are all these materials in here, to, oh yes, we see everything's in here, there's no major deficiencies. And then additionally, you see both in DEQ's MEPA analysis and the record of decision that DEQ arrived at the conclusion that all the necessary materials have been provided to the IRP. Frankly, this is something that DEQ deserves deference on, identifying whether or not a certain document has satisfied a seismic probability analysis is something that's in DEQ's expertise, and with all due respect, not the court's.
The district court went on from that point in response to the explanation I think that you just gave her. You know, it included in its order that defense, but then continued on page 32, the argument fails because DEQ must review all mine operating permit applications, quote, for completeness and compliance with the requirements. You would then would you disagree that all the rules were not followed here in the way they should have been?
I disagree because it's right there in the record. DEQ affirmatively states both in its MEPA analysis and the record decision that all of these materials were provided to the IRP. DEQ made that determination. DEQ checked all of the boxes and made sure the IRP got the materials that they needed, just as it's commanded to do under statute. I'm going to turn to the issue of nitrogen, and Justice McGrath, I think you got the description of the facility almost perfect. The only thing that I just want to make sure is clear to the court is that this non-degradation standard is in effect from July 1 to September 30th. It's only in place for 3 months of the year. And what Tintina is going to do is end discharging this treated water during this period to make sure that there are no violations of this water quality standard. And there are two lines of analysis that ensure that the Smith River and both Sheep Creek are going to be protected. The first is DEQ looked at this and found that attenuation will occur and will remove the total nitrogen, which is the only pollutant that exceeds this non-degradation standard that applies. And additionally, as Justice McGrath pointed out, this is subject to monitoring. As you recently noted in your Water for Flathead's future decision, monitoring along with satisfactory standards is sufficient to prevent environmental harm. And while we think attenuation is going to occur and the science supports this, monitoring is the backup that makes sure that we're right. I also want to talk about.
So let me just clarify, have you clarify. So the non-deg standards only apply this in the summer months, essentially.
Correct.
And so the plan is that there will not be any discharge into Sheep Creek during those months.
Correct. And the only, just to characterize plaintiffs' arguments, they argue that there's going to be a migration that occurs at the end of June that may show up in, August or September, but the attenuation that we've described is sufficient to make sure that doesn't occur, and monitoring is the backup. With that, I'd urge this court to overturn the district court and reinstate the permit. Thank you.
Thank you. That concludes the argument in this matter. We will take this matter under advisement, and we will issue an opinion in due course.